everyone. Welcome. Thank you so much for coming to our second installment in the series about AI ethics. And this series is a product of a new Danielson Ethics Initiative Collegiate program, fellowship program that we started this year. And Professor Margot Kaminski is one of our first recipients of the fellowship. And so this series was really her brainchild to bring together different experts from the field to talk about AI ethics. And it's such a current kind of timely area and absolutely fascinating to get to explore these topics. So as I mentioned, we are on the second lecture of the series. This will be the last one for this semester. And there will be two more lectures coming up. The next one will be February 27th. And the final one will be March 20th. Both of those will again be at the law school, but should be evening programs. So please keep an eye out for those. And if you're interested in attending the entire series, all you have to do is sign up on the Silicon Flatirons website, and you'll get information about each one and how to RSVP. So please make sure to do that. So today we have the benefit of hearing from Professor Kaminski herself on AI ethics. She is an associate professor at the University of Colorado Law School and the director of the Privacy Initiative at Silicon Flatirons. Margot specializes in the law of new technologies, focusing on information governance, privacy, and freedom of expression. Recently, her work has examined autonomous systems, including AI, robots, and drones. In 2018, she researched comparative and transatlantic approaches to censor privacy in the Netherlands and Italy as a recipient of the Fulbright Schumid Innovation Grant. Prior to joining Colorado Law, Margot was an assistant professor at the Ohio State University Moritz College of Law and served for 3 years as the executive director of the Information Society Project at Yale Law School, where she remains an affiliated fellow. She served as a law clerk to the Honorable Andrew J. Kleinfeld on the Ninth Circuit Court of Appeals in Fairbanks, Alaska, and she'll be joining us today to talk about the law of AI ethics. Margot, it's great to have you.
So I'm going to just jump into it because I want to make sure that we have as much time as we can to cover this and still have room for discussion. My talk today is going to be talking about the legal side of basically what you heard in the first talk in these series. So I will still be talking about some basics, but hopefully can get through them a little bit quicker. I'll begin the talk by discussing the definitions that are out there as to what AI systems are. I'll then turn to ethics, and in a nutshell, talk about what ethical AI is. And then I will turn to the developing law of AI ethics, which is where the meat of my research has been for approximately the last 5 years. And I will note that the law of AI ethics, and this is something I've sort of come up with for this talk, comes in roughly 3 flavors. They are not strawberry, vanilla, and chocolate. The 3, I wish they were. Law isn't as tasty. The 3 flavors are roughly a risk regulation regime, a rights-based regime, and what a pair of colleagues and I have been calling put a human on it or slap a human on it, which is basically to try to solve all problems by making AI not AI and putting a human back in the loop. So I'll start with this question of what are AI systems? And this should be very familiar for any of you who attended my colleague Harry Sturgeon's talk at the Scott lecture the other night. An AI is simply put a computer program. And it's used to automate tasks that otherwise would have required humans. And there are, roughly speaking, 3 different types of these programs, 3 categories in which these programs fall. The first is machine learning, which is an algorithm that basically operates by using a large data set, analyzing the information that's in that data set, and extrapolating rules from that data set, which leads to one of the significant ongoing problems with AI, which is that it replicates what it finds in its data sets. The second type of AI system is knowledge representation or logic representation, which is more what people were trying to do with AI, some 40-ish years ago. And that's the idea that if I'm an expert in law, I could map out my knowledge set through a series of decision trees. And you as a computer programmer could basically replicate that set of decision trees with a computer program that could do it more accurately and quickly than I could. And then there are also systems that represent a hybrid of these 2 different types of programs, and so pose issues that stem from the nature of each of these different kinds. So what AI resolutely is not, and again, if you attended Harry's lecture, you would be very well aware of this, is not the general artificial intelligence that we see in movies. So unfortunately, AI is not Scarlett Johansson in the movie Her, nor is it the robot Ava in Ex Machina, nor is it the friendly robot in Robot and Frank. By the way, if you haven't seen that one's less watched than the other two. I highly recommend it. Instead, it's basically a computer program that has certain characteristics and has predictable flaws. When you look at how the law defines AI, because my focus today is on the law of AI ethics, you see sort of a pattern emerging, which is that different legal systems have been attempting to define AI less by identifying a particular type of program and more by talking about the social uses and impacts of the uses of artificially intelligent systems. So as an example, if you look at the language of the draft EU AI Act, which is top-down hard law proposed in the European Union, you see this very general, very broad definition of AI as software, right? And you kind of see Harry's three groupings of AI software in the EU AI Act definition, with the first being a machine learning approach, the second being logic and knowledge-based, and the third being weirdly broad. Right? Statistics. Statistics is AI. Most computer scientists will look at this and be like, what? No, that's wrong. Then, however, the Act, like many other proposed laws, attempts to narrow its scope, not by leaning on a technological definition, but instead by saying we're focusing on where the rubber hits the road, right? Where AI has significant social effects. And we see this same pattern of broad technological definition for purposes of future-proofing the law, combined with narrowing onto only serious effects in many different examples of the beginnings of AI law. So this one I'll try to keep relatively brief because I think Casey did an amazing job of covering these in her talk. The harms of AI systems are out there, right? AI systems are already widely in use. You use AI systems or are subject to the use of AI systems all the time. In 2018, for example, Uber's self-driving car killed a pedestrian in Arizona. In a couple of years ago, I think it was like maybe 2017, 2016, a group of researchers out of MIT noted that facial recognition, which is widely used across the country, both by private organizations and by law enforcement, had been replicating biases in its data to the tune of basically making it the case that if you were a Black woman subject to this particular facial recognition algorithm, there was only a 1 in 2 chance that you were actually going to be identified correctly. Since then, facial recognition programmers have become very aware of this and have made those odds less bad. Then we have examples of the widespread use of AI tools in screening and ranking job candidates. We actually talked about this in my seminar a bit yesterday. There's a scary class of AI called physiognomic AI or chronological AI, which is effectively AI that tries to make judgments about you based on your outside appearance. We know this is junk science. We know that it effectively tracks pretty closely to what the junk science of phrenology did back in the 19th century. There's an example of an AI harm occurring in the healthcare context that I think is really interesting and worth teasing out here, where well-meaning hospitals tried to use a risk prediction algorithm to channel patients that were at higher risk of worse outcomes into higher levels of care. So the idea was, I run this algorithm on all of your patient data, I figure out, oh, you're much more likely to need better care, I'm going to channel you ex ante into better care programs. But what they found out, and this is from an article in Science, was that the algorithm actually started using a proxy for health, which was cost, and started identifying the patients that were most likely to be expensive, which weren't necessarily the patients that were most likely to be actually ill. And the patients that were more likely to be expensive also happened to be patients that were more likely to be white. So Black patients at a much higher rate did not receive recommendations that they should get the added care, and there have been studies since then trying to mitigate those harms. We see AI in predictive policing, where effectively police use artificially intelligent systems to either try to identify individuals who might be at a high risk of offense or reoffense, a la Minority Report movie, so there's one where you can cite an actual pop culture reference, or they use AI in heat mapping, which basically tries to determine where in particular neighborhoods they might want to send increased police forces. And once again, you have this problem of the data that they are using to map where crimes might occur is data where past crimes have been policed. And so existing racial biases in policing end up getting imported into these algorithms, which accurately predict that those neighborhoods will be more policed in the future. And finally, I've talked about this in a recent talk in the past. There's the recidivism risk algorithms, which basically try to predict for a person who is arrested or is at the end of a trial what their sentence should be or whether they should receive bail. So when you look at all of these examples of harms, they really come from a common set of patterns. And this is the motivation for there being an omnibus law of AI, a law of AI that potentially would cut across sectors and applications because it identifies the same stuff as happening that needs fixing. Garbage in, garbage out is this example that I was talking about with the facial recognition algorithm. So if you train a machine learning algorithm on a biased data set, it will reify the bias that's in that data set. Another example might be if you ask a computer to predict who is more likely to succeed coming out of med school, and you train it on data that has many more years of men going to med school than women, the algorithm is going to predict accurately that its past graduates and future graduates are most likely to be successful men. But that's not reflecting the capacities of graduates, that's reflecting what societal biases were already in the data. Then we have issues around target variables. So that health algorithm that I cited is an example of this, where you have an algorithm that is supposed to be aiming at whether somebody is healthy or sick, and instead what it's aiming at is actually how pricey a patient is going to be. This happens quite frequently in machine learning, depending on the degrees of supervision that it might have, human supervision it may have. You may be thinking the algorithm is going to predict one thing, but it's actually predicting a proxy for that thing. And therein lie the errors and biases. And then finally, a problem that some have called, I am adopting the term for this, abstraction, which is the idea that an algorithm gets trained on data for use in one context and then gets used by people who are poorly trained to use it in another context entirely. And there you get your Mondrian painting because that's abstraction. All right. So what is ethical AI? So here we are, sponsored by an ethics organization. And when you look into the question of what is ethical AI, this conversation started, it started way before this, but it sort of bubbled up in my community roughly 10 years ago. And what it looked like was moral philosophy, right? Because you have this crazy idea that you replace human actors with AI actors, and you've got to determine what is morally good or bad, and what is right or wrong, and how is Ava from Ex Machina going to solve this problem. So this manifested as a bunch of conversations about the trolley car problem. Anybody know what the trolley car problem is? Right, you're standing there, the trolley car is coming barreling down the track. Do you let it hit the group of the large group of people, or do you flip the switch and you kill the single person? And this basically indicates, am I utilitarian in that I think that the greater number of people should be saved, or am I Kantian in the sense that I believe every human life deserves dignity and we don't use people as means towards an end? That's not actually what we're talking about when we're talking about AI ethics. For the most part, with the exception maybe of self-driving cars, this is not what the ethical puzzle is. Instead, when we talk about ethical AI, what we're really talking about is norms embedded in institutions. So we're talking about the norms of software engineers, or the norms of a company, or the norms of a coalition of multi-stakeholder groups around practices that exist in a company. And so we go from norms to corporate practices to more formal standard setting to even increasingly forms of soft law. What's soft law? Like fuzzy and lovable? No, so soft law is basically law that doesn't get enforced. And this is the big question is like, well, what use is that, right? If you don't have the person with the stick behind the law saying you must do this, why would you follow the law? These largely end up serving as sort of norms creating and enforcing mechanisms, and sometimes eventually down the line can become the basis for actual hard law, as we're just starting to see happening in the AI ethics space. So to impress upon you just how fast this has been happening and how much it has proliferated, in 2019, an Arizona State University study found 634 soft law AI programs. So at least 630 different, basically stakeholder groups coming together at varying degrees of formality to come up with what the principles for ethical AI should be and how they should be enforced. And again, I'll point out that was from 2019, right? And we're now almost at 2023 somehow. So this number is way out of date, and the number of sources now is considerably higher. So what does this look like? What do these principles of ethical AI actually look like? I'm drawing here from a soft law instrument that comes out of the US government and is a work in progress, the NIST AI Risk Management Framework. And this comes from the second draft of the NIST AI RMF. And if you look at it, you see that basically you have a core backdrop to what ethical AI is understood to be, and then a number of sort of principles, their goals that rest atop that backdrop. At the core of ethical AI is supposed to be accountability and transparency. We'll talk much more about that when I get to the actual laws. The various goals for ethical AI are that it be valid and reliable, that it be safe, so your self-driving car doesn't kill a person, that you manage fairness and bias, that it be secure and resilient, explainable and interpretable, and privacy enhanced. This is not just some set of principles that NIST came up with out of the blue. They have a really helpful table that you're all going to get lost in because you're going to stare at it up here instead of at my face. But basically, they trace the origins of these principles to a number of different instruments of varying degrees of softness or hardness. So they find for their principles of validity, safety, managing bias, security, transparency, and accountability, et cetera, they find origins in the OECD's recommendations on AI, for example, in the draft EU AI Act, and even in an executive order. So we are seeing some significant convergence on these groupings of principles as being the core of ethical AI. Now, because this is a Daniels Fund event, I wanted to also draw sort of connections with regular business ethics, because some of this stuff is just old hat, right? If you're doing compliance and you're working in a business, a lot of these principles, these really high-level principles, are things that should be familiar to you. So the Ethics Fund principles are as follows. I'm not going to read all of them, but I am going to select a couple of them that should reverberate with the principles I just read to you from the NIST framework. So we have trust, right? You have to build trust to be ethical in business. We have accountability. We have transparency. We have fairness. We have respect, and we have rule of law. I'm leaving out integrity because, integrity is not a real ethic. All right, so to map this back onto the AI risk management framework from NIST, we can see all of these principles here, right? We have transparency as one of their core principles. We have accountability as one of their core principles. We have fairness, right, which has a very specific term or specific meaning in the AI context. We have respect, which largely gets exhibited through a series of individual rights. I'll come back to this in the legal portion of this talk. And we have a lot about trust, right? That you can't have, in fact, the core of how ethical AI is described is that it's described as trustworthy AI, trustworthy AI. Okay, and then, just a little afterthought, we have rule of law. This I kind of put as the last thing because the law's not there yet, right? So if you have rule of law and you have respect for rule of law, but you don't yet have law, this is a little bit circular. Okay, so I'm going to talk just for a minute because it's fun and I get to play with AI to do it, about what ethical AI might look like in practice. So I'm going to focus in on the issue of bias and fairness and turn to basically a toy that I've been playing with over the last couple of months. I got access as an AI researcher to DALL-E 2, which is an AI system that can create art from a natural language description. So I've told you guys, right, and Casey did the same, and Harry did the same, that machine learning algorithms tend to learn by combing a huge data set and pulling out features of that data set and then making predictions on the basis of it. So if I had a data set, as DALL-E 2 does, of all the pictures of CEOs on the internet, and I put in a search term that is CEO, what do you think you might get? White men. Thank you. Right, we got white men, right? And this is not because only white men can be CEOs. This is because that's reflective of what is in the data set, right? And the majority of pictures that are out there on the internet of CEOs, probably pictures of white men. So when I entered CEO into DALL-E 2, that was 100% what I was expecting, and this is what I got. What happened? I know Casey knows. What happened?
Someone tweaked the AI to be less racist?
Someone tweaked the AI to be less racist, right? So there was either some kind of audit or an impact assessment. There was definitely a lot of corporate shaming after a number of examples of this were brought up across, search engine optimization. And so the AI does not produce what you would think it would produce on the basis of how you understand machine learning to work. All right, this is fun, okay? So the other thing I want to illustrate is that AI is brittle. So if you go in and you tweak the AI, you don't necessarily know what my smart little devious human brain is going to come up with as the next question. But AI often works best in a contained set of circumstances. It's not generally, there is no general artificial intelligence. And so when I put in a tweak, things get a little bit weird. So one of the things you can do on DALL-E 2 is to put in the style of art that you want, okay? So I asked it for a CEO by Rembrandt. You want to see what it did? So I see this as an illustration of its anti-bias intervention fighting with its Rembrandt, right? But we've got some more white guys as CEOs. And then finally, just because it is so creepy, I then decided to search for the President of the United States of America in a style of techno-futurism. All right, so this is funny when it's art, right? Or maybe deeply scarring. But this is art, right? But if what you're asking the AI to do is not to draw a picture for you, but to predict who is going to be the best employee, or to predict who is going to be the person most likely to succeed at law school, or to predict basically what the test results would be for somebody who couldn't take a test during a global pandemic because we didn't have testing in person, this is not funny, right? Okay, last one. Last one is that I asked AI to DALL-E 2 to illustrate the law. And I show you the results for this one, not because it illustrates bias necessarily, but it just illustrates how weird AI is and that it's not a human and it's not thinking and it produces strange results. All right, so these are each separate images. If you look at this, it's like kind of plausible. You're like, oh yeah, there's a gavel and there's a scale of justice. But if you look at the guy on the far, I'm assuming guy, the creature on the far right, right? The scale of justice is hanging off the gavel and it's not attached. And if you look at the little red gavel person creature thing, it's taking the gavel apart, right? like this is, AI is strange, it is brittle. If we rely on it to make serious decisions, this is effectively what's going behind the scenes. All right, that's my best argument for governance. So the developing law of AI ethics is as follows. As I promised to explain, it comes in roughly 3 flavors. We have flavor number 1 is basically let's solve the problem by making it not AI. Right? That's intuitive, it's cheap. A lot of regulators try to do it. I'm going to try to convince you it's a terrible idea, at least when done badly. Option 2, and this is also extremely dominant, is risk regulation. So risk regulation is basically, in a nutshell, ex ante, meaning before the harm happens, regulation that aims to identify and mitigate risks so that on a large scale, you don't have the kinds of impacts that we're talking about. And then finally, there is the sort of counter movement to the risk regulation approach, which is a rights-based, and by rights-based, I mean individual rights-based approach to AI, where if you're the person upon whom the decision has been made or affected, you're the one who has some kind of right to try to counter or contest that decision. So just by way of backing up a little bit, I think it's important to understand that each of these approaches, well, maybe except for the slap a human on it, which we'll talk about shortly, each of these approaches actually has some really valid reasons why you'd want to use it over the other approaches. And to understand this, you have to understand what on earth regulators are trying to do. Like, what's the actual harm of using artificially intelligent systems? The first goal that regulators have is an instrumentalist goal. So the idea is basically, here's a system, we've been using it, it's biased, fix the bias, right? Go back in and fix the bias, mitigate the risks, and then you can keep on using the system. So that's an instrumentalist approach to regulating AI. A justificatory approach, and if you remember going back to our AI risk management framework, you see this at the base. It's like the bottom line for NIST's approach to ethical AI. Says, actually, one of the big problems here is not that we need to fix the system, it's that we don't have accountability over the system. So we have no way even of getting to fixing the system if we don't know what it is the system's doing. And somewhere in its weird little system AI program, it's making conclusions that involve broken gavels, right? So the justificatory approach is really talking about, I want to see the reasoning, or I want to have oversight that's going to convince me that the reasoning or the conclusions coming out of this AI are justified on a systemic level, if not on an individual level. And then finally, we have the goal of protecting dignity and autonomy. All of you who have had me for privacy law know that I'm a dignity fan. That puts me in a minority in the United States. It does not put me in a minority in Europe. And I think it does not actually put me in a minority with respect to most of the lawmaking entities around the world that are now thinking about how to regulate the use of these systems, possibly including our own White House. So let's start with flavor one, because it's kind of the most fun to reject. How do we solve the problem of AI? We make it human. So the one quick fix for making AI not AI would be to put a human back in the loop. And I have here an illustration for you of different ways of understanding human involvement in AI decision-making. So human in the loop basically means the AI is not making the decision by itself, that human involvement in that decision is required for the decision to be made. A human on the loop, by contrast, is a set of decisions where a human sort of standing by supervising, but might not be involved in every individual system decision. And then a human out of the loop is like level 5 autonomy in autonomous vehicles, where the system's making all its own decisions. Humans not only aren't intervening, but they might not even have capacity to intervene. So regulators have basically looked at the version over on the left and said, oh, everybody's coming and complaining to us about AI and the problems with AI. Let's fix it by just making it the version over on the right. Okay? And one example of this is from the very well-intentioned and largely well-designed Directive on Automated Decision-Making from the Government of Canada, which divides AI systems into 4 levels of risk. So this is not levels of autonomy. This is levels of how risky the government thinks the systems are based on how significant the decisions are or the type of system being used. And there's a human in the loop component of this, where the Government of Canada says, if we make a government decision at risk levels 1 or 2, you can make it without a human in the loop. For risk levels number 3 or 4, put a human in the loop on it. And the idea is that's going to do something, right? Maybe it'll make the instrumentalist concerns better. Or it'll make the justificatory concerns better because you have a human doing the reasoning. Or it'll respect human dignity because the human's there involved in the decision instead of relying on a machine. But what I and co-authors have observed in a paper conveniently titled Humans in the Loop is that this doesn't make things better. So a human-machine system is actually not the sum of its parts. It's not what people do well plus what machines do well. It becomes this complex system, which is subject to a whole host of known problems, which include things like a handoff problem. If you think about an automated car and the idea that a car might pass off to a human driver when it encounters an obstacle that it doesn't recognize, that's not going to work if you pass off the control to the driver at 1.7 seconds before impact, as has happened in automated car crashes, right? You have inadequate training of the people who might be experts in their domains, but are not experts at using machines, and so don't know what is coming at them from the machine. Conversely, you have inadequate design of the machine and that it's not adequately communicating things to the people. You have what's known as automation complacency, which is basically if a person works with a machine repeatedly and sees it working for a long period of time, this is like Homer Simpson's in The Simpsons and the nuclear power plant, right? It's just like, it's working, and he's gonna stop paying attention. And then you have failure cascades, where something that goes wrong in a human-machine system can get much bigger. This is 3 Mile Island or the Boeing 737 MAX, where it can get much bigger than the individual problem in an individual system because they basically end up magnifying each other as the problems cascade and compound. And none of this is new if you work in engineering, right? The fields of human-computer interaction and human factors engineering have dealt with this stuff for a long time, and they look at regulators like the Government of Canada that say, put a human on it and say, well, that's not the solution you think it's going to be. All right, I want to keep on time and make sure you have time for discussion. So second option is risk regulation, okay? And this was one where the lawyers look at it and say, this seems like this makes a lot more sense. It's complicated and it requires hiring a lot of my students, so what's not to love? And risk regulation is in fact emerging as the dominant approach to regulating AI. It's typically not like, the Food and Drug Administration licensing the use of drugs. It's not that level of heavy touch, top-down risk regulation. It's typically centered on making companies, and it is largely directed at companies, do an impact assessment, map out where their data comes from, talk about whether they think there's bias in the data, mitigate the bias in the data, and then go off and roll with it, right? What it's contrasted with is it contrasts with liability. So yes, there is liability for a car crash when you have the crash of a self-driving car. It is not clear what liability is available if, for example, you're subject to an automated hiring algorithm, if you're subject to an algorithm that makes predictions on you on the basis of your looks, if you're subject to an algorithm that predicts what your test scores would be based on past performance as a student. And so we also don't see any forms of individual rights, and I'm kind of layering this on top of liability because you can have individual rights that are not supported by lawsuits, but instead are supported by regulators. And most of the risk regulation doesn't propose those either. And the risk regulation being proposed lacks accountability. So it lacks public transparency. Companies are doing basically self-assessment and self-regulation and are struggling to figure out how to deal with the impacts on particular communities or marginalized groups and don't have good systems in place for getting input from those stakeholders into the risk mitigation process. So again, in the interest of time, I'm skipping this. And I would say that when you look at risk regulation in other fields, it's not a neutral tool, right? It sounds great, let's look for the risks, let's mitigate the risks, let's fix the risks, but risk regulation actually has significant limitations as a regulatory device, including that it works best on quantifiable problems. Is fairness quantifiable? Is privacy quantifiable? All of you have taken this class with me, no, right? It's not structured to make injured people whole, so you'd have to come up with something clever like a victims' compensation fund if you don't have liability and you're using risk regulation. We see none of that in the risk reg proposals coming out. Doesn't provide civil recourse, lacks a feedback loop and gets stuck in stasis, and frankly, risks capture. If you have a risk regulation regime that's largely delegating risk regulation to private companies with minimal regulatory oversight, it's pretty clear what's going to happen and that the check boxes are going to all be marked and that the products are going to go out and nothing good is going to happen of that. All right, so again, I'm happy to talk about this in the discussion, but I want to get to conversation. The draft EU AI Act is all this, okay? It's risk regulation par excellence. It basically says we're categorizing AI into 3 buckets, and in the bucket that we care about, we're just going to employ impact assessments, risk mitigation, maybe some post-market measures. Okay. So now we come to the one I'm most happy about, the rights. And when we look in the recent news, the White House recently released a draft blueprint for an AI Bill of Rights. And many people look at this and think, oh, wow, Ava's going to have some rights. Right? That's not correct. That's not what they're talking about. What they're talking about is effectively data protection. So the White House, this is not law, this is aspirational, said if AI is going to be used widely, these systems should be safe and effective. There should be protections against bias. There should be protections for privacy. There should be individualized notice and explanation. And you should have human alternatives, consideration, and fallback, which in a nutshell, this part right here is very similar to the individual rights established in the EU's GDPR. Okay. So I'm going to point at both of these because basically the notice and explanation in the GDPR are supposed to enable the ability to challenge an AI decision. So this brings us to the conclusion of the presentation, which is that I think there's opportunity here still for intervention in this path dependency down the risk regulation path. And there are at least 3 different reasons why you would want to have an individual right in this system. The first, the justificatory reason, is because basically if you get an explanation, a meaningful explanation of an AI decision, you're forcing accountability over that AI system and the use of that system. A right to contest AI also affords you dignity, as is the case in due process law in the United States, where if there's in the face of a significant decision about your future, you're afforded a way to come in, and I can talk in greater detail about what this might look like in the private sector context, but to come in and say, you made the wrong decision, you need to hear my voice, right? And the last one, which I think is kind of the most important, even if you're fully instrumentalist and you say, Kaminski, I don't buy into this dignitary stuff, and I think that the justificatory stuff sounds awfully nice, but very legal, what are you talking about? And you think, I just want to fix the tool and make the tool better so we can use it. There are instrumental reasons to have an individual right as well, which largely have to do with the fact that this risk regulation is concentrated in the private sector, doesn't have adequate regulatory oversight, and basically doesn't have good ways of checking the power of private companies that are going about making these decisions on their own. So you can think about an individual right as being a counterbalance as a part of regulatory design that brings in more transparency through explanations to individuals, and over time can show you made a bunch of bad decisions about a bunch of people. Actually, your system's really not good. We should pull it off the market. Okay, so in conclusion, I'm not rejecting risk regulation entirely. I think it should be part of the solution. I definitely don't think it should be all of the solution, and particularly not in the version that it's been proposed. Rights need to be part of the solution, and we're finally seeing in the United States some like very begrudging moves in this direction. But they have to be carefully thought through because rights aren't there in isolation. They're actually part of this larger regulatory system. And then as a last and cursory point, if you take one thing away from my talk today, it is that humans in the loop are hard. That's the end.
So I am going to ask a few questions to get the conversation started. So while we're having this discussion, please think if you have any questions for Professor Kaminski. So I was thinking about how you were tying some of this to the talk that I gave a few weeks ago. And one of the things that I was wondering was how these different types of frameworks might think about unintended or unanticipated consequences of AI. So a lot of these things, you know, the generous interpretation of most of these kinds of AI harms are that they didn't mean to. And so one of the things I was thinking about was whether you think that a risk-based framework or a rights-based framework, how those might treat that topic of these kinds of things being very unintended.
Yeah, so the appeal of the risk-based framework is twofold to answer your question. One is that it forces companies or government institutions to have an intent. It basically forces the navel gazing that requires them to make some decisions that otherwise they can just sort of throw their hands up in the air and be like, I didn't think of that. So it forces them to do the thinking. One of the things that's missing from risk regulation as it's currently being proposed, and I want to be clear, like the different frameworks they do vary. So like the risk regulation you see in the EU is different from the risk regulation you see at NIST, is different from risk regulation we see in proposed impact assessments in other places. With that caveat, nearly none of them use tools of what's known as resilience, which basically, again, comes out of different contexts where we regulate high-risk systems, say, for example, like the use of nuclear power plants, where you ask the user of a technology or the developer of a technology to do some forecasting. And this when you gave your talk, it had a lot of resonance for me with that missing tool, right? Where it's like, when you sit down and you do your risk mitigation, you should also be trying to say like, it's on me to figure out the ways this could go wrong. And you can actually use law to require that, right? And currently we are not doing that.
So one thing that you didn't quite get into here that I was wondering if you could talk about a little bit is the sort of different levels of thinking about risk regulation. So like, do you think that there is a point at which the outcome of risk regulation should be, don't make it? Just don't make the thing. The thing should not exist. Do you think that's the type of regulation that should be happening?
Yes, I actually think that and this again resonates with what I heard you saying at your talk. I think that this is part of the move, like the framing move of using risk regulation and impact assessments, as well-intentioned as that sometimes is, moves us away from a conversation about bans, right? Because it takes what Jessica Eaglin's referred to as a techno-correctionist approach to AI, presuming that the thing can be fixed and that there's some point at which, every type of AI can be fixed. Now, the EU AI Act is a little different from that in that its highest risk category is actually banned. So that particular risk regulation regime contemplates a bucket in which AI systems go to die. But in the US, when you see various model laws, that's not really there. And I don't know that any regulator in the US is yet thinking holistically about like, if we're going to create the category of systems that should be banned, what would that category look like? I wonder, this is off the cuff, but I wonder if you could probably design a risk reg system that would say, you know, at a certain threshold of snake oil nature of this, like where basically all you're doing is promising that this technology can do something that it's not going to deliver on, you're not only, you know, not good to go if you conduct your impact assessment, but actually you're going to be subject to FTC enforcement because you've effectively lied about saying that this tool is something that works when it doesn't, it's snake oil.
And so you did talk a little bit about the EU, and you mentioned the AI Bill of Rights here. Do you think we are going to see actual regulation based on the AI Bill of Rights or something similar?
I think it's so, I'm so intrigued, right? So basically, if you look at the various so back up for a second. The European Union's General Data Protection Regulation, which is basically its big data privacy law, has within it a regime for governing AI, and that is both risks-based and rights-based. And when you look at the US laws that have been trying to enact something like the GDPR, both in Colorado and in California, we're not fully importing what the European Union did, but there's a weird little hook that might be the hook in those two legal regimes for bringing in individual rights, which that you have a right to opt out, right? You have a right to opt out of automated profiling with significant effects. And who knows, the regulators who are interpreting those regimes could say that means you have a right to explanation, right? You have a right to explanation of the decision so that you can decide if you want to opt out. And there have been some stakeholders that have been pushing for that. I don't have much optimism in general about getting a federal law in this space. We've tried to get federal data privacy law for what feels like thousands of years. But I'm sort of curious about what norms on entrepreneurship you might see at state levels that, you know, hook onto the wink from the White House AI Bill of Rights and say, look, it's consensus, right? It's not just that we, Colorado and California, are driving particular momentum in this. Like, look, the White House likes it too. Yeah.
So another thing that I was thinking about when you were talking about the difference between a risk versus rights kind of framework is that there's a tendency sometimes in the law to think about the most people or the average person or the reasonable person, but AI harms tend to disproportionately impact marginalized groups. So do you think that a rights-based framework would also sort of mitigate some of the problems of like the same people being left out of a risk analysis over and over?
I'm nodding, that doesn't necessarily mean I think yes.
Yeah.
So the big hurdle for a rights-only approach, which is why I don't advocate for a rights-only approach or a liability-only approach, is access to justice. People from marginalized communities typically don't have time, don't have money, don't necessarily have access to great lawyers. And so leaning only on that to do this work, I think would be a mistake. And there is a risk that you end up putting in place a rights-based framework, and the people who decide, this is like the right to be forgotten, the people who decide they want to opt out of the system are the people who are least likely to actually be hurt by the system. So one of the focuses where I'm going next, which actually has its parallels in our colleagues' work in environmental law, is on how you deal with getting stakeholder input into risk-based regulation, and whether there are ways to design risk-based regulation, which I think there are, to communicate with and amplify and leverage power out of marginalized communities, so that you're not depending on individuals to come forward and complain. That said, I think individual rights are a great fail-safe, right? So if you have an individual harmed by an AI decision and says, explain this to me, and the explanation is basically, this AI is racist, and they take that to a journalist and the journalist writes that story, that's like a pretty important regulatory lever too, and I wouldn't want to give up that lever just to have the stakeholder input that may or may not be effective.
Why don't I open it up for questions if we have questions in the audience, if not, I'll keep going, but anyone? Yeah, over here.
So I think the idea of right to opt out and how that might force private actors to actually explain themselves is like a really good idea. I had never thought about it, but most of the privacy laws that they have passed in the US, like, you know, California and Colorado being the two primary ones, and as far as I know, none of them have the private right of action, unlike the EU kind of. And so that would be like a great kind of fail-safe measure. What, like, US is, I think, the most litigious society in the world. Why do they leave that part out? And how do we kind of force them
I think you just
to?
answered your own question. Okay, so actually, I'm gonna answer this in a very sardonic way. So, private right of action is a huge bone of contention in discussions of federal data privacy law because effectively, the companies that are now pushing for harmonized federal law because they don't want to navigate the cost of like 50 different regulatory regimes don't want the cost of a private right of action. So the sort of grand compromise, but a lot of the people who are pushing for federal data privacy law are saying exactly what you just said and what I largely believe, which is like it's toothless if you just give it to a regulator that's undercapacitated. So one option is you give the regulator more capacity and like real rule-making abilities. So some of the solutions have gone after the design of the FTC. Another option is that you create this sort of cabined mini private right of action, which is what the ADPPA, the proposed federal bill, had in it. Quite to my surprise, honestly. I was surprised they even got that far. Now, my sardonic response is that recently read a piece by a scholar who works in basically national security law, who wrote about how there's a private right of action in the United States to enforce against the material support for terrorism. So you can actually, like, as a private actor, sue people because you think they've been providing material support to terrorism, which is one of the sort of most First Amendment questionable like statutes out there. And nobody was concerned about us being a litigious society when that was put in place, but they're really concerned about it when it comes to suing Facebook. Meta, sorry.
Thank you for a very entertaining presentation. I just want to disclaim briefly that I'm an engineer, not an attorney. I also have a very long background in software and hardware. I just wanted to ask, you said something, and I wanted to see what you thought of it. You said humans in the loop are hard. And I wanted to point, before I ask my question, I wanted to point out that it's very obvious in the United States that as far as regulation is concerned and new innovation, everybody tries to have a light touch, whether you're talking about telecom, whether you're talking about chemistry, whatever it is. But we have a significantly unique situation where the technology involved is self-evolving. And my question, when it comes to why are humans hard, is that in a lot of ways, the technology can be very predictable. And it becomes hard, though, to get that predictability in front of the right people. So what would you say to a different kind of self-regulatory regime where if you're developing AIs, you get to have some, well, I'll just say responsibility with your technological rush forward. And it could be pretty lightweight, and it could be based on functionality and an assessment, a self-assessment, as in self-regulation, on what harms could be derived. Now, there's always unintended consequences, I get that, but I'd love to understand if there's anything different about AI with respect to introducing light touch regulations in a new industry in the United States, and what you think that might be.
Yeah, I think this is in some ways your law of the horse question, right? So yes, I agree with all of the premises of that question, which is that the United States, when you look at our regulation of the internet, for example, or you look at our, sort of our conversations around, the Internet of Things or big data, like all of that stuff basically says, we're going to start from a place of you do it yourself. When the harms show up, then we'll regulate. Except we didn't. So my reaction to your question is actually less that the burden is on the regulators to say AI is different, and more that the burden is on the regulators to say, like, what were you doing for the last 20 to 30 years? So that's where I'm coming from. To the question about self-regulation, this is one where
I call it It said delegated self-regulation.
Yeah. So, or co-governance or collaborative governance. So I think I have more optimism than a lot of people in my field that there's a way to structure delegation to the private sector, which has more of the expertise. Like, we're never gonna hire good enough engineers in government to do perfect oversight. But if you're gonna delegate to the private sector to figure out how to fix things itself, and there's a bunch of tools you can use, like using broad standards instead of specific technical standards, or saying like, do these processes and appoint these people in your organization. But if we're gonna do that, there needs to be a stick. Like, there has to be an incentive. It's like, when this goes wrong, somebody pays. We just don't have it. Like, you may have it in physical products context where a physical crash leads to liability, leads to losing money. You don't with a lot of the other kinds of harms that we're talking about.
Interesting. Thank you.
Thanks so much for the question.
So just following up on that, your response, and the question of how effective sort of self-regulation or self-analysis is, doing your own assessment within the industry. What are some examples of that work?
Yeah.
Because I would argue under the GDPR, in terms of the really big companies, the big tech companies using data that impacts privacy, that has been very ineffective in what works of the fines. So, but I don't know, I'd like to know if you have an opinion.
No, I agree with you. This actually resonates with work of another person on our faculty who's written about this in the copyright context, Cristalia Garcia, where like the idea is you need to have this, the stick needs to be big enough that you're incentivized to not face the enforcement. And if you have not enough enforcement, which is sort of the argument about the GDPR, right? Like it has great enforcement on paper. In actuality, regulators with really limited capacities takes a really long time to issue fines, and often they're a drop in the bucket for these large companies. Same thing's true of the FTC, the Federal Trade Commission in the United States, right? So if you're sitting there and you're like, all right, I'm ticking the boxes and I'm going through and checking to see like whether I've complied with this really vague law, you have every incentive in the world as a cost-saving measure to not really comply with it unless you think that the risk is you're going to end up with a big fine if you don't comply. So I guess I would say I agree with you. I think that it's only going to work, the delegation only works if you actually have the sticks to back it up. I think you have to run, don't you?
No.
Oh, you're good, okay.
I think we have about 5 more minutes, I think.
Yeah, I do think we have a class coming in here.
Yeah,
in about
maybe 3 more
7
minutes. So like
Yeah.
one more question, or I can,
If someone else has a question, they should go, but if nobody else has a question, I'll go next.
are there any other questions? I didn't see any hands, so.
What is being proposed in terms of the actual regulatory agency or the regulatory body?
Yeah.
And how to handle the expertise required, the competitiveness with regard to getting that expertise and then the dynamic nature of the technology.
So these are all different regimes and none of them does it well. And that's a great question. So in the EU, the risk regulation of AI gets glommed onto existing regulatory bodies. They're not proposing creating a new agency. And there are 2 different types of regulatory bodies, and basically member states get to choose what they're going to use. One would be to use your existing data protection agencies and just use the mechanism built by data protection law. So it's, your expert in data privacy is going to also be your expert in AI, but we know they're under-resourced. And the other would be to use products regulators, because there's a system for moving, say, chairs around the European Union where you undergo a third-party inspection regime, you self-certify to it, and then these regulators say, full conformity assessment passed, and you get to move your chair around the European Union. Problem is the people who do chairs don't do AI. And so there's a big risk that for a number of these countries, they're gonna shove the risk regulation through their products regulators, and that's not gonna work out well either. You all feel optimistic?
Just let it come in.
Yeah.
Well, thank you very much.